Welcome, everyone. Welcome to our Learn Community Education webinar. I am Dee Childers with Life Changes Elder Care Consulting and Vice President for Learn, as well as the Community Education Director or Chair. And today our topic is responding to elder financial abuse with Corey McCool. Learn is Lifelong Education and Aging Resource Network, and we're an Idaho-based nonprofit organization with the mission to provide community education on aging and caregiving topics. And we are part of the Leaders Network for the Society of Certified Senior Advisors. The content that's provided to you today is for informational purposes only and not to be considered legal, financial, or health advice, other than Corey is an attorney. Consult with your legal, financial, and healthcare or other service providers before taking action based on this information, because specifics do change. I'd like to introduce our sponsors today, and we're so pleased to have Peggy Barnworth with us as retirement coach, CPA, financial advisor. The Boise Retirement Coach helps you plan for your retirement journey from pre-planning through legacy planning. As well as our co-sponsor is Granny on the Move. And Granny on the Move acts as general contractor for seniors who can no longer live at home independently. So websites for both of these folks are up here. And today, our presenter is Corey McCool, dear friend from McCool Law. And I am so pleased to have you with us today, Corey. May I read your bio, or would you like to introduce yourself?
Oh, go ahead, Dee.
All right. So Corey is a graduate of the University of Wyoming College of Law, his JD in 1988. He served as a judicial clerk with Judge James Wolfe, Sheridan, Wyoming, and he was a law clerk with the U.S. General Counsel for Lloyd's of London in New York City. Corey spent 20 years as a high school history teacher and then returned to the practice of law here in Idaho. His law firm is McCool Law, located in Boise, Idaho, and serving the Treasure Valley. Corey has one law clerk, Melissa Allen. She just graduated from the University of Idaho College of Law, and their law practice focus is on elder law, estate planning, guardianship, and probate. In addition to his law practice, Corey serves as president of the Idaho Guardian and Fiduciary Association. And in his spare time, when he has some, for fun, he and his wife, Marianne, enjoy exploring the great outdoors of Idaho, where they run their border collie, Flora, and they occasionally try a little fly fishing. How wonderful. Well, Corey, thank you so much for being here. I'm just going to unshare my screen, and we're going to focus on you today. So as long as I find that button, oh, there we go. We're going to go back to here. And here we are. So Corey, please educate us.
Okay, thanks, Dee.
Dee, I think you may need to still stop sharing.
Oh,
yeah, I'm seeing a bunch of stuff on my screen.
you are. Well, I just hate when that happens. I don't want to share anything. Here we go. How's that?
Okay, we're looking better. So I'm seeing introductions, sponsors, presenter.
Yeah, we're still seeing the presentation now. I might be able, let me see if I can.
How about there?
There we go.
Yeah.
The magic of two screens leaves me somewhat confused.
Okay, I think we're good. Hey, thanks, Dee, for introducing me, and thanks to Learn for allowing me to present today. And I want to give a shout out to all the great work that Learn does for our community. I encourage you to peruse their website, where you'll find all kinds of fantastic resources available. And they're just doing a wonderful service to our community. And so I'm happy to be a part of that. And so today I'm going to be talking about responding to financial abuse. And so this is my first go around speaking on this issue in this way. On several occasions, I've presented on preventing financial abuse. Obviously, prevention is best whenever possible, and the types of things we can learn on how to prevent financial abuse are critical, and the more we can share those strategies, the better. But sometimes people come to see me and we're kind of past the prevention stage. The abuse has already happened, and we're trying to see what can we do now that someone has lost a substantial portion of their money, to the extent that there are remedies. We all have heard or read about the graying of America, or the fact that we're having an increasing proportion of our population are elderly folks, and we're aware of some of the disabilities that go along with Alzheimer's or dementia. But I'd like to think of our issue of vulnerable adults as being much broader than just perhaps the elderly or people like that. It's really any person who has a cognitive problem in terms of processing information. A certain part of their brain in the executive decision-making has a disability. It makes it difficult or impossible for them to connect facts with conclusions. And if that part of your thinking process is disabled, then you can be vulnerable to a person who you might trust, who can trick or deceive you into making a really bad financial choice. And actually, there are many situations where there are people who are quite capable of managing their life, taking care of their home, fixing meals, socializing with family and friends, going shopping. They appear to any casual observer to be perfectly in control of their lives. And yet hidden is that a small part of their brain that is focused on financial decision-making could be disabled and could easily go undetected. Such a person might have someone come and do some lawn work for them that should normally cost $50. And then the person says, yes, that will be $5,000. And because of that person's disability, they don't recognize the difference between 50 and 5,000, and they write the check and off the person goes, and the other person is none the wiser. So there are folks who sometimes have this disability. Sometimes people don't notice it, but there are people out there who can definitely take advantage of that. When this kind of thing happens, when someone has been deceived into transferring money that shouldn't have been transferred, our challenge in the law, or the challenge with the prosecutor who wants to convict someone for committing a crime, or for family and friends who want to help this person, this is a unique type of situation where something has happened, but it's the proving of it that is particularly difficult. For one thing, the victim may have no memory of the event, and so they're not able to talk about what happened. In another situation, or in the same situation, the person who's a victim, the abuser may have isolated this person. They may have used their powers or abilities as a caregiver to keep family and friends away from the victim. And so the combination of this person's loss of memory, along with the fact that there's no helping people around to witness the event, all we have is the result. And sometimes it's very hard to determine how this person, what happened to this person's money, and because there's no witnesses. And as if that's not bad enough, the abuser is very likely, or very often, is a person that is trusted or should be trusted. They might be a close family member or a long-time friend. And in that situation, it wouldn't be unusual to expect the victim to perhaps have made a gift or two. It's not unusual for parents to help their kids out. There's nothing illegal about that. We often expect our parents or grandparents to give us a helping hand on occasion. And so in terms of abuse, what we have to try to do is put the pieces of the puzzle together and determine whether this transaction was a loving gift, intelligently made by the giver, or was this person a victim of fraud and deceit? So,
Corey, if I could just kind of interject there.
yes.
I've had clients, I've had two different clients that were financially exploited by their church.
Right. Yeah.
Which is
Yeah.
really, really hard because they thought they were doing something helpful and there was some reciprocity there, and in the end ended up losing their home.
Yeah, and like you say, Dee, in that situation, it's not unusual for a person to want to donate to their church. And our challenge is to distinguish between what was a thoughtful donation versus someone who got tricked into doing something that they weren't really capable of making that kind of decision. And like you say, Dee, sometimes we're talking about someone who has lost their nest egg. They have lost their life savings, and they've put themselves in a situation where they're unable to pay for their needed care. And worse than that, they could get into a situation where not only can they not pay for their care, but in the eyes of Medicaid, when they apply for public assistance, Medicaid looks at their financial reports, and from Medicaid's point of view, they've made a series of gifts to somebody, which Medicaid looks at as a way to try to qualify for Medicaid. And from Medicaid's point of view, they've made themselves ineligible for public assistance. And then there they are, not able to pay for their own care, and they might have a lot of hoops to jump through to get themselves in a position where Medicaid will pay for their care. And so the result of this abuse can be pretty grim. So what I want to look at today are some of the strategies and tools that are available whenever possible to try to recover, when we can, what we can. And I can think of one person who came to see me a number of years ago. It appears that her daughter had obtained a power of attorney over mom, and she then withdrew about $150,000 from the account to pay off her student loans. And then she moved to Japan, married someone, and there she was in Japan. And so, I was looking at trying to help this person out, and we tried a few things here and there, but unfortunately, the wrongdoer had flown the coop. It was not easy to figure out how to get that back. And the wrongdoer claimed, well, Mom, don't you remember you said you wanted to help me? And no, there was no memory of that. And so you had a situation where the proof was tough and the person was not easily accessed. And so far as I know, nothing ever came of that. So, but I want to talk about another case that's a little bit more positive. It's a simple case, but it's something to keep in mind. This woman's name was Dorothy, and she was a victim of a Nigerian scam. And she had fallen prey to this person over the telephone. And what she wound up doing was going to the Verizon phone store for reasons that she could not explain, and bought $10,000 worth of very expensive high-end phones, boxed them up and shipped them to a location in Florida where they vanished into thin air. She had been told a story, and she didn't realize the story was false until she got her phone bill and learned that the person she was talking to was actually out of country. And then she started piecing things together and realized that the person that she thought she was helping in Florida was never in Florida. She reported it to the police, and nothing much ever came of it because, it's out of country. And then she got a bill from Verizon for something around $10,000 to $15,000 for these phones that she had purchased. And so in this situation, as it turns out, with a couple of nicely worded letters, we were able to persuade Verizon to forgive the debt. And I remember also mentioning to them, so when this 85-year-old woman came into the Verizon store to buy $12,000 worth of phones, did your clerk ask them any questions as to why they needed all of these phones and that they were buying them on credit? And, the thing is, wouldn't it be nice if the clerk had simply said something? Gosh, Dorothy, I wonder if you might be victim of a scam here. Tell me more about what you're doing. But the clerk said not a word, probably was happy about the commission. And so we were able to persuade Verizon that while they were not guilty of anything criminal, they admitted that they maybe could have done more to help this poor lady. So in this situation, we were able to get them to just drop the debt and kind of forget about it and move on. So what I'd like to take a look at for just a second is the fact that we are talking about people stealing money. The wrongdoer is they're stealing, they're robbing, they're bad people. They should go to jail. The problem is, from the prosecutor's point of view, is the question of proof. And how do we show that the person who has taken this money is guilty of a crime? So due to the difficulty of proof, there is a law passed in Idaho and other places, and it deals specifically with exploitation of vulnerable adults. And what it does is it lowers the burden of proof for the prosecutor, that makes it easier for them to get the wrongdoer. So if a person is guilty of exploiting a vulnerable adult and the amount taken is worth more than $1,000, then that person is guilty of a felony, which is punishable by up to 10 years in prison and a $25,000 fine. So if we can prove this, that's a pretty serious consequence. So so the first thing is, what has to happen in order for this statute to become usable? Well, first of all, the victim has to be a vulnerable adult. And so according to the statute, a vulnerable adult is an adult who is unable to protect himself from abuse or exploitation due to a mental impairment which affects the person's judgment or behavior to the extent that they lack sufficient understanding to make or communicate decisions regarding their finances. So if you have a person who's a vulnerable adult, then that allows the prosecutor to move forward to protect this person because they're unable to protect themselves. So the next thing that has to be shown is that this vulnerable adult was exploited. And to exploit means an action which may include unjust or improper use of a vulnerable adult's financial power of attorney or funds or property by the wrongdoer for profit. So if you have a person who's vulnerable and the other person has taken an unjust action to relieve that person of their property, then they are liable to a felony with a pretty significant financial, a pretty significant penalty. So that's what the law requires to be shown. But the prosecutors are still, they're a little nervous about dealing with a lot of these situations because what's going to happen is that the wrongdoer is going to throw out some defenses and it's going to make it difficult to show that a crime happened. And they're going to say things like, well, it was a gift. This person told me I could have this. They might even have something written down in an email or a letter or something like, I always wanted you to have this. And so from the prosecutor's point of view, these are not easy cases, even with the help of this statute. But it's not something that should be ignored. And if you have a friend or a family member who you believe is a victim of someone who has wrongfully taken advantage of their vulnerability, then you should absolutely do everything you can to document what happened and certainly make law enforcement aware of what happened. And hopefully there's enough there that they can move forward. What we would like to see is the wrongdoer get the punishment that they deserve for their actions. That's not really my area because I'm not a prosecutor. I don't get to put people in jail, but you know, we do try to help the prosecutors by creating a train of evidence that we can just hand them and make their job a little bit easier for them. And the more we can provide them in terms of evidence, the more likely they are to be able to move forward on something if they feel that they have a good case. Okay, so aside from criminal felonies, putting people in jail, what can we do to what really where we are lots of times is we just want the property back so that this person can take care of themselves. They're not destitute anymore. Now that's what's really critically needs to happen. So I want to focus first on what can the victim do to protect themselves. Lots of times when we see these types of situations, what we're looking at is where a person has given a trusted person a power of attorney. And it might be that this is a matter of convenience, that they need help with paying bills, or maybe they're not able to get out around town as much as they used to be able to. And so they give a trusted person the power of attorney that allows this person to act as their agent, to conduct transactions on their behalf without them having to do it themselves. So they give this person a power of attorney, and the person goes out and they help. They help with all kinds of things, paying for bills and buying things that need to be bought and helping the person manage their affairs. But then after a while, the victim feels that, I wonder if my trusted agent is taking advantage of me, and they don't feel like information is really being shared with them, and the agent is going off and doing these things. So I've had folks come to me and they are complaining about their power of attorney, and sometimes they're actually surprised to learn that they can terminate the authority of the power of attorney. They just simply need to call them up on the phone or write them a letter and let them know, you are no longer my power of attorney. And the other thing is they can force them to share the records of the transactions that they've conducted as power of attorney. And the one caveat that I need to add, if a person is terminating a person's power of attorney, they also need to be sure to let financial institutions know that that power of attorney has been terminated. So if there's a bank that you're using, you have to communicate with that bank and let them know that my trusted son or daughter is no longer my power of attorney. And so,
Corey,
yes.
is the best way to do that then by letter? I mean, I would think that rather than just a phone call and talking to some teller or something, right? Best way is to do it by letter.
Absolutely. Every time you get a chance to put something in writing, that needs to happen. And with the bank, I think in person visit, if at all possible, or by letter. The thing is, banks are doing a lot to help protect people from abuse, and I think they're doing a much better job than they were several years ago. But there's still plenty of dropping the ball and things happening that maybe should not happen. I'm aware of, for example, a case where someone had been declared incompetent by a court. A conservator had been in place. The bank account at the bank was in the name of the conservator for the benefit of this person who was not competent. And still, this person, the incompetent person, went to the bank with a friend, withdrew money from the account, and the teller just said, here you go, here's your $3,000. And then they just turned it over to the abuser, the person that really led to the creation of the conservatorship in the first place. So I was astonished. I'm like, why do you think we have this conservatorship? And so I can tell you, in this situation, the bank actually admitted their error and put the money back into the account. It was the bank's expense. It was the bank's fault. They did it. But, in answer to your question, Janet, what you want is to get to make sure as much as you can that you've turned this power of attorney off and that everybody knows it and that it's in writing. If a person has been acting as power of attorney and they get notice that they are no longer power of attorney, and then they go ahead and try to do a financial transaction anyway, then that's straight up larceny. Once they've been notified, if they still try to control property with the power of attorney that's been terminated, that's criminal liability and fairly easy to show.
Corey, is in that case, kind of follow on to Janet's question, should there be a certified letter to the power of attorney? So there's some evidence that they've sent that their power has been revoked?
Yeah, absolutely. The certified letter is going to help with that. And we want to put that nail in just to close that door and to prevent that happening any further, and to make sure your evidence is in place in case that person continues to be an exploiter. And from Janet and Dee's questions, it looks like we're probably dealing with a person who we may be looking at additional steps anyway. There's probably been a lot going on. It's not just that we don't want them as power of attorney anymore. We're probably building a case for a number of transactions that need to be reversed.
Hey, Corey, can I ask another question?
Yeah.
So have you ever seen a situation, or, what would you do in a situation where someone has power of attorney over someone who had capacity, some recognized capacity issues, but had not been determined incompetent? It was like more of a convenience power of attorney, but that person essentially accelerated into a situation where they should have probably been under conservatorship and weren't, and somebody else influenced them to cancel the power of attorney and reassign it. What do you do then? I mean, it was like power of attorney was in place that was legitimate, and somebody else inappropriately influenced and essentially took advantage of the vulnerable adult to cancel that power of attorney and replace it with one that was not on the up and up.
That raises an excellent issue, Dara. And a lot of people in their estate planning create the power of attorney so that they don't have to worry about their family going through proceedings for a guardianship and a conservatorship at some point in the future. And usually that's going to work. However, a person who has capacity issues, as they develop these cognitive problems, they might become delusional, for example. They might create suspicions against a family member that are completely not founded in reality at all. And so this trusted person is actually a good trusted person. They're not trying to take advantage of mom at all. But unfortunately, the person who has a cognitive problem has developed these fantasies that, they're victimizing them. And so what you're saying is this third party comes in, intervenes, and persuades the disabled person into terminating the power of attorney.
Yeah,
so
terminate what is still truly in the person's best interest.
That's right.
Yeah.
So what we have there is a situation where this person, when they were healthy and thoughtful, they did everything they could to prevent the necessity of a guardianship proceeding. But until a court says that you're not competent based on the medical evidence in front of them, then you are competent. As an American, we're free to do whatever we want until the court says otherwise. And so in that situation, the trusted person who was the power of attorney who suddenly got cut off, they probably better start asking questions and finding out what's going on. They probably better do it pretty quickly to see if somebody has come into their parent's life or whoever the victim is. And they may have to move for an emergency guardianship, even though this person did everything right. They made their power of attorney, but now, the courts are going to have to step in and establish a conservatorship. And one thing the court's going to be looking at is when this person was healthy and were not suffering from a cognitive problem, they're going to look at the person they chose. That's going to be the most likely person the court's going to want to go to. So the person who had been acting as power of attorney may wind up becoming a conservator because the power of attorney wasn't strong enough to deal with this particular disabled person. So I don't know if that makes sense, but we can always revoke power of attorneys, and we can do all kinds of things. we can do really stupid things. And as long as we understand, what we're actually deciding to do, then we're allowed to make those kinds of mistakes. So what you're talking about is perhaps a situation where they're making decisions, but those decisions are not based in reality. They're based in a delusion or a cognitive problem. And so the court's going to have to step in and remedy that and establish a court supervised conservator to protect that person from themselves.
And it's so tricky because, as we all know, right, there are no clear rules lines around capacity, right? And so in those early times of cognitive impairment where it's not obvious to everyone, as you started this presentation, it feels like a really risky area for people, right? That's probably the riskiest time when they could be taken advantage of before they're acknowledged to be impaired.
Yeah, you're exactly right. And it's really a case-by-case situation. It's a person-by-person situation. It's not a yes, no. It's very much a sliding scale. And people can have all kinds of abilities, and their opinions and decisions and choices need to be respected as much as possible. But then you have situations where that same person, like I said, they don't know the difference between $50 and $5,000. So, you just have to hope that the process that we go through in establishing guardianship, everyone does due diligence. They find out what this person's capabilities are so that we can respect that as much as possible, but then also protect them from whatever the disabilities might be. So what the court wants to do is they want to respect the person's choices that they made when they were healthy and when they were able to make those choices and they understood what they were doing. So even though it may look like the court is taking away a person's choice, what they're really doing is they're saying, we respect the choice that you made when you understood the question. So, and like you say, though, that's easier said than done. So we do what we can. Okay, so what we're looking at then is a person who, we're going to say, for the sake of argument, this person does in fact have a cognitive disability that makes them unable to understand financial questions, and they are now vulnerable to potential abuse. So the first thing we want to do is say, what can this person do for themselves if they still possess enough ability to terminate a power of attorney, to seek legal advice, to reach out to family members and say, hey, I'm really nervous about, I thought this person was helping me, but I'm beginning to wonder, And so in this situation, the person is helping themselves and they may be reaching out to other people to come in and help them. And by the way, I'm just going to throw out something that I always try to include with any power of attorney that I draft for a client. And that is, when they are naming someone to be their agent as their power of attorney, I always ask them, who else do you trust? And what I try to do is include that second person on the power of attorney, and what that second person does is they receive a transaction report once every 6 months or once every 3 months, just letting them know what the power of attorney has done. And so just to clarify, let's say we have this person, they're getting up in years, and we'll call this person mom. And then mom has 2 kids. One's son and the other is daughter. Son lives nearby, and so mom picks son to be their power of attorney. And then daughter lives in New York City, so she's not super convenient to help out. But in the power of attorney instrument, son is required every 6 months or whatever seems to be appropriate to send his sister a report of everything he's done. And that way the sister kind of knows what's going on, even though she's not living close by, and that communication is in place. The sister living in New York is not a power of attorney, but the actual power of attorney is required to communicate with what's going on. And so when you have, what the law says is, the law says you are required as a power of attorney to keep records of everything you do. But unfortunately, the law does not have you do anything with those records. So they just sit there. And you know what people do when they have to keep records, but they don't report them to anybody? After a while, they just sort of forget about the whole thing. You know, life takes over, and before long, a year's gone by and there's no records and no one's able to know what's going on. So when you have this person out there that is kind of, we're communicating with another family member, whether it's Uncle Fred or a friend or whoever it is, and then that we kind of help keep people honest with a little transparency.
So Corey,
Yeah.
I'm assuming then that there's verbiage relative to that says when the principal has been declared incapacitated, they have to do that, because prior to that, the power of attorney, you can have a power of attorney and not be doing anything. So there was worded.
That's right.
On that line. Okay. Interesting.
Yeah, usually what I have is language like what you're saying. They don't necessarily have to be declared incapacitated, but there's language that if there are no transactions, then there's no need to report. You don't have to just say every 3 months, say, oh, nothing happened. Because, you know, you might have a situation where someone is stepping in and helping someone out on a regular basis, but the principal is not necessarily declared incapacitated. So for me, on my instruments, the trigger is, have there been transactions that you conducted as power of attorney? And if there are, then you need to report them.
Not just as a helper per se, right? So that's the difference. So you like as long as the parent still has capacity, the power of attorney might be the child who's helping, but the parent's still fully aware, and that wouldn't be.
That's right. So if the parent and the child are sitting there in the living room looking at the computer, purchasing something on Amazon, then, you know, in that situation, mom's saying what she wants. So the person who's acting as power of attorney, they're not really acting as power of attorney necessarily. They're just helping navigate the computer. Mm-hmm. So, you know, in that situation, but if you're out there and you're doing things as an agent on behalf of the principal, then you're acting as a power of attorney. And the law requires that you keep records of everything you do. And so a well-drafted power of attorney instrument tells you what to do with those records. And hopefully there's a trusted person that you can share those with. It's not foolproof, it's not perfect, but, you know, it's been my experience, if you have more than one person in the kitchen, a little transparency, it's a little harder to be, it's a little harder to abuse a person. And the thing is, I think lots of times situations, what's really going on, it's not really purposeful abuse. It's just sloppy record keeping that winds up looking like abuse sometimes. So anyway, not everybody has a whole army of trusted friends. So sometimes people, it's hard for them to pick even one person they trust, much less two. It just depends on the family dynamics and so forth. But that's just a strategy that I encourage, trying to keep people out of trouble. So, okay, so what I'd like to take a look at is a situation where the victim really is not able to protect themselves. They're in a situation where they do in fact have a disability and they are being victimized by a wrongdoer, and somebody else is going to need to step in and protect them. That person could be a guardian / conservator. Somebody has perhaps been running their life pretty well, but due to declining health, they've gotten into a situation where they can't do it anymore. Family and friends have noticed there's a problem. They've gone to the court, and the court has named a guardian and conservator to step in and protect them. In that situation, and we're going to focus on the conservator, which is the person responsible for financial affairs. When that conservator steps in, they need to conduct an inventory of the property that this person has, and they need to start taking a look at bank statements and what's going on. And so what might happen when that conservator starts doing their inventory and figuring out what's going on, the whole picture might look rather suspicious. There might be some transactions that don't make sense. And in that situation, it's the conservator's responsibility to find out what's been going on and see if there's any remedy. And before I get into those remedies, I want to suggest another situation, and that's where the victim has died. They've passed away, and in that situation, somebody is named personal representative of the estate and probate. And so just like the conservator for a person who's alive, for a person who's passed away, the personal representative comes in, they start conducting their inventory, finding out what's been going on in this person's financial life. And what they recognize is there's been some very mysterious transfers that don't look right. So that conservator or that executor of the estate are called personal representative. Both of those situations, that person has a responsibility to find out what's been happening and is there anything that we can do about it. So okay, so the first thing is, and we've talked about a power of attorney. If someone steps in and they start digging around a little bit and they start finding these gaps that don't make sense, it looks like maybe our person was a victim. If there's a power of attorney out there, then either the conservator or the personal representative has the ability, has the legal authority to demand that the power of attorney produce financial records that shows everything that happened. They have a legal obligation to keep those records, and if asked by a personal representative in probate or a conservator, then they have 30 days to produce the records. If they're not able, they can ask for a 30-day extension on top of that, but failing that, they can be hauled into court and forced to explain under oath why they've not been able to produce the records. If there's gaps and they were power of attorney and they're not able to show that those were legitimate expenses, then we can start looking at whether there might have been some wrongdoing. But the first step, usually going through a person's financial records, if someone's been acting as a power of attorney, the first step is often demanding disclosure of everything the power of attorney has done, so we can start putting the pieces of the puzzle together. Okay. The next thing I'm going to look at is it's a legal doctrine called undue influence. If somebody has been a victim of undue influence, then the court has the power to go back and set aside transactions that perhaps happened. So we're just going to say, for example, that our victim conveyed their house to a person. They wrote a deed and they just said, I hereby convey my property to my trusted friend. And it's recorded. And so now this other person is the owner of the house. So in that situation, the deed speaks for itself. When you sign that deed, it conveys the property over. And so what we're concerned about here is the possibility is that the person who signed the deed, they were a victim. So one thing you can argue is the person who signed the deed simply lacked cognitive ability to understand what they were doing. So in that situation, you could prove with medical evidence that they didn't know the difference between a property deed and the Sunday morning comic books. They're just completely out of it. They had no idea what they're doing. In that situation, the deed would be found to be invalid. That's not always easy to do, especially if the deed was maybe conveyed 2 or 3 years earlier. So that would be possible if you have someone who just didn't know what a property deed was. On the issue of undue influence, though, if you can show that this person who signed the deed and conveyed the property was a victim of undue influence, then the court can set that deed aside and return the property to its rightful owner. The court's going to look for 4 issues to determine whether that's proper. The first thing that has to be shown is the victim is vulnerable to influence. That could be that they have a cognitive disability, but it doesn't have to be a brain disability. To be vulnerable to influence might be you could show this person for many, many years has trusted on the wrongdoer's advice. This person has a history of just letting this person run their financial affairs, and they're not necessarily mentally disabled. They just trusted this person. And so if you can show that, that through the record, through the evidence, this person's been just relied on this person, then you can show that they meet the first condition, which is vulnerable to influence. The second condition is that the wrongdoer had the opportunity to exercise undue influence. So in that situation, you're going to show the wrongdoer on many, many occasions was alone with the victim, and they could weave their tales and their stories and convince this person that conveying your house to me is a really good idea. And the victim is isolated and is not able to talk to anybody. And the other thing you're going to want to show is that the victim did not have access to independent advice. There wasn't like a lawyer there representing them or any other person. So the first 2 issues is you've got a person who's vulnerable to influence and they're isolated. And so you have a situation that looks suspicious. So the third issue is that the wrongdoer has what the law calls a disposition to exert influence, which means that you can show that there's just been a pattern over a period of time. This person has been influencing or kind of controlling this person's life. And you can show that they've been managing their affairs, they've helped them make decisions, they've been maybe a little pushy and controlling. And if you have witnesses that can talk about the type of relationship the wrongdoer had with the victim, then that's part of your proof. And the final and last piece is the result of the disposition is shocking or surprising. So say, for example, the house is the main possession of the victim, and they have 3 children, but for some reason they gave the house over to just one of the 3 children, and the other 2 were left with nothing. And there's no record to show that there's any reason for that. I mean, people can obviously leave their house to one person and not their other children. But if it's shocking to all the friends and family, like, wow, we never saw that coming. She got along with their other kids just great. Like, in that situation, it's a shocking result. So if you take everything together, you have a person who's vulnerable to influence, they've been isolated, the wrongdoer there's a history of controlling behavior, and there's this shocking result. In that situation, the judge can say, we're setting this transaction aside, we're making that deed go away. And by the way, this can also work with a will. So if someone wrote a will that was a product of undue influence, then the court can set that will aside. I don't mean to make this look like this is an easy case to show it all. In fact, it's very hard, because lots of times the evidence, it's like everyone knew what happened, but proving it is quite a different story. But there is a piece of law that can help out a lot. And because normally when you go to court, you have the burden to prove what it is you need to prove in order to win. But in this area of law, there's something called a rebuttable presumption. And what happens in this situation is, if the wrongdoer holds a fiduciary responsibility, then it shifts the burden of proof to the wrongdoer. So if the wrongdoer has a power of attorney, and you have a shocking result where the power of attorney has just gotten this great gift that everyone's surprised about, the wrongdoer has to prove that it was legitimate. And I can tell you, in court, when you can shift the burden of proof over to the other person, that's a happy day. It's like, okay, good. All I have to do is sit back and punch holes in it. So if you have a situation where you have a family member or a friend who appears to be a victim of undue influence, it looks like they've been tricked into doing something, and the person who did the tricking is a power of attorney, then that's worth taking a closer look at, because it forces that power of attorney to prove what happened was legitimate. And they might be able to do that. You know, people are allowed to disinherit some of their kids to the advantage of others. People are allowed to make gifts. They're allowed to do that. What we want to do is make sure that the gifts are legitimately that person's decision and not the result of coercion or trickery or deceit or something like that. Okay, so that is the legal doctrine called undue influence. It can be applied to any legal transaction. It can be applied to a will or a trust that someone wrote. It can be applied to conveying property over to another person. So in all those situations, it is possible to reverse those transactions. All right. So Another strategy or another possibility is a situation where you have a bank statements, financial transactions from bank statements where there are mysterious transfers that don't make sense. In this situation, it's not really undue influence. It's possibly what the law calls conversion, which means the unlawful taking of property. If you're going to convict someone of conversion, if you're going to convict someone of stealing in a criminal court, it's called larceny. And so you can show that this person stole the property intentionally, and they can go to jail for that. But outside of criminal court, if you're just in regular civil court, what you want to show is conversion. And so in that situation, the person has taken property that's not theirs, and it was not a gift. So when you're looking at the bank statements and there's transfers from one person's account to another, and those transfers are happening on a regular basis, then someone's account is being drained. And so the question is, why are those transfers happening? And it could be a gift. It could be that the caretaker needs money to buy groceries. The person who's receiving those transfers could come in and show, this is covering the expenses that I needed to buy medicine and groceries, and here's all the receipts. And we look at it all and it's like, okay, that makes sense. Yeah, even though it happened over a period of time and it looks like, oh gosh, that's $40,000 in transfers. When you kind of look at what the person was doing, it could make sense. But in a situation where it doesn't make any sense at all, and there's no evidence to show legitimate reasons, then we could be looking at essentially stealing. So likely this is what's going to happen when you have a power of attorney and we produce the financial records and we review what happens. It's the power of attorney's responsibility to demonstrate that those transfers were legitimate. So that could create a legal judgment showing that the wrongdoer now owes the victim, I don't know, $100,000. That's great. You've got your judgment. So the next trick is to turn that judgment into real money. And that's not always as easily done. Sometimes money has a way of going away. Our wrongdoer might be a drug addict and he's been taking money to buy his drugs, so you're not going to ever see it. You're not going to get that money back. But if the wrongdoer does have money, or if they do own property, and you do get that judgment that shows and there's been some stealing going on, then it is possible to get a remedy. Or, you may have a situation where the victim has passed away and they still have some estate left, and the wrongdoer, we can show that the wrongdoer has absconded with all of this money. And so it would be possible to assert that that's basically can be taken out of their inheritance as a type of advance on their inheritance, if you can show that it was a wrongful transfer. And so that would be conversion and financial. Conversion is the taking of property. whether it's money or a car or items out of the house, paintings off the wall, jewelry, different things. All of those things sometimes walk away and aren't there anymore. But again, as always, there's the difficulty of proof. So, but if you can show that this person took the property, Facebook Marketplace, by the way, is a great place to look for evidence. I've had a couple situations where we've found stuff being sold on Facebook Marketplace. And I was like, oh my gosh, that's great. There it is for sale. So
Thanks for giving me the evidence I needed, right?
yeah, that was awesome. Yeah, we got the price and everything. So so anyway, those are that's what I have for the presentation. I'm sure I've overlooked stuff that I plan to talk about. Does anyone have any thoughts or questions on some of these issues of getting property back when we can?
I actually have one question. I'm going to flip it the other way,
Yeah.
right? In a situation where perhaps, I guess it would be the same thing as the power of attorney situation, but where maybe there's a sibling dispute and maybe a parent did legitimately give something to a child, and the other sibling tries to challenge that. Is it very similar to that other situation where you just have to start showing that chain of capacity, and the decision was made when that person had full capacity?
Yeah, that's exactly right. And that's the situation we're dealing with. The presumption, the place that we want to start with is that the person who transferred this property knew what they were doing. Like we said, people make gifts all the time. We give money to our kids, we give money to the church. There's nothing wrong with that. And lots of times we have a situation where the person receiving the gift is also a caregiver. And so the giver feels indebted to that person. And so they start making gifts. And so it's not necessarily wrongful behavior at all. The problem gets to be where the person doing the giving is also suffering from some mental disabilities. So when we started, I said, we want to do everything we can to respect a person's choices, to respect their right to control their lives as much as possible. Where we have a situation where somebody wants to, if you're the caregiver, if you're the good son or the good daughter, and the parent wants to help you out, my advice in that situation is to bring in a third party. An attorney would be a good choice, and documents can be drafted. And so in that situation, when the supposed victim comes to my office, the first thing we're going to do is the possible wrongdoer is going to go somewhere else. They're going to leave. And so that we can create that conversation without the possible wrongdoer in the room. And this independent person who has no family connection, they're just there to do the right thing, can have a conversation, and they can assess in their professional judgment whether this is really what the parent wants to do. In that conversation, the lawyer might be like, I really feel like this is really what they want, but I'm also a little bit concerned about how they're kind of repeating things, and maybe the thoughts are kind of going one way and then another, and a little bit of confusion. And so at that point, the lawyer's like, I kind of feel like this is what they want, but I'm also not sure about this person's ability to make decisions. So in that situation, the lawyer is going to ask for a medical assessment or a cognitive assessment. And so we can kind of get a reading on where this person's at. And then in that situation, you have a record. You've got this doctor who said, yeah, there's some mild dementia, there's some confusion here, but they understand what they're talking about. And then you've got the lawyer who feels the same way. The papers are drafted and signed. And then, years later, the elderly person passes away, but you've got that record in place that shows this is really what the person wanted. And so that poor sibling who got left out, they can complain all they want, but now we've got a written record. And so it's gonna withstand challenge. That disgruntled sibling is going to try to hire a lawyer, and then that person is going to look at what happened, and they're going to see that document drafted by a lawyer and with the medical assessment there, and they're going to say, your mom, that's what she wanted. Deal with it.
Yeah. So
Don't
like everything
waste your
else,
money on me taking this to court because you're going to lose.
so like anything else, if it's a transaction that someone else may feel is the least bit controversial, get it documented by the appropriate parties. Yeah.
Now, if you're buying your grandchild a new bike for Christmas, you probably don't need a lawyer for that. But if you're trying to transfer a substantial amount of money, or if you have a situation where you've got a kid and they need a bunch of money for a house deposit or whatever, and in Treasure Valley, who doesn't need a substantial amount of money for a deposit on a house? You can help that person, and you can say, hey, look, this is coming out of your inheritance, but you want a piece of paper that shows that that's what you're trying to do, so that, later that can't be challenged as some kind of a trick or deceitful thing. That would be my advice on that.
And Corey, I put in the chat box that this is also where an elder mediator may come in handy as well, which you are an elder mediator. So yeah, so we do have the elder mediators available as well.
Janet, thank you. That's a really good point. And, I've been talking about the wrongdoer and the victim. Lots of times what we have is not really a wrongdoer and a victim. It's just a misunderstanding, a failure to communicate, or, somebody's feels that something is wrong when it's really not. And so what the mediator can do, instead of having a trial, is the mediator can just help people establish better lines of communication. And sometimes people need to be reminded that even though your brother destroyed your toy when you were 5 years old, or they stole, something from you, or they pushed you down in that mud puddle, we're just going to have to let that behavior go. And, let's all grow up here and be adults, because lots of times in these family disputes, there's stuff that happened a long time ago that it makes it difficult for people to perceive what's happening right in front of them. And a mediator can help create those family conversations that can prevent the lawsuits from ever happening, and people kind of realize what's going on. So get things documented. If someone wants to make a significant transfer, make sure that we can show later that it wasn't a fraudulent transfer. And then two, what we have lots of times is the so-called wrongdoer has been working really hard to help somebody as a caregiver, and they feel like they deserve something a little extra. But sometimes their perceptions of what is a little extra winds up being way beyond what's realistic. And so it's like, for the past 2 years, I've been taking mom to Albertsons every Saturday, so I deserve the house. It's like, wow, that was really nice of you to give mom a ride to the store, but that house is worth $600,000. That's a little, that doesn't really make sense. And then the wrongdoer says, well, you never did anything. And it's like, well, I came over and fixed the plumbing, and I did this and did that. And sometimes one person, all they see is all the great things they did. They develop this idea that this is something that is owed to them. And what they wind up doing is essentially stealing, but in their mind, they're not stealing. They think they've convinced themselves that this is just what they're owed. And so in that situation, rather than having the whole thing melt down into a big court battle and probate, Janet, let's get that mediator in there first and help people communicate.
Excellent points. Thank you so much, Corey, for a wonderful presentation today. It's a topic we can have lots of conversations with, lots of education with, and consequently we have IGFA and we have Java and we have Learn, and so other opportunities to discuss. Any other questions on closing here? All right, well, I'm going to do my best to get us back to the right screen again. And I'm going to thank you, Corey McCool. Thank you so very much for being our presenter today, providing us real specific examples and great ideas about how to avoid appearing to be in a position of exploitation, and to help better understand that whole concept and context. So thank you very much, Corey. I appreciate you and your expertise today and sharing that. So thank you.
Well, thank you, Dee, for having me on, and thanks to Learn for all the great work you guys are doing.
Thank you. I would like to just close by also thanking again our sponsors, Peggy Farnsworth, the Boise Retirement Coach, and Granny on the Move, both excellent services and opportunities to get in touch with these folks. Clearly on the web is a great way to go. If you are not already on the Learn mailing list and would like to be, you will get a notice post meeting today or tomorrow that about where handouts are, and et cetera. And if you would like to join our mailing list, you do need to confirm. We don't just add you. So check your junk folder in the next couple days if you don't see something coming from us. And upcoming presentations are the beginning of August. Hard to comprehend, we're already to August. So this is the schedule that we have through the rest of this quarter, and more opportunities for education in future quarters. But we have some really interesting and kind of different topics that are coming up. So be sure you register for those. And if for some reason you miss them, please catch them on our website. And with that, I thank you all for being with us today. And I'm going to close our meeting and say thanks very much. Stay cool. And we'll talk to you soon.